The relitigation exception in the Anti-Injunction Act allows federal courts to enjoin state courts from relitigating issues from federal courts. But does this exception prevent a different party from litigating a similar issue in state court? In Smith v. Bayer, we'll see whether a federal court exceeded its authority when it enjoined a state court from hearing a request for class certification that the federal court denied. George McCollins sued Bayer in state court in West Virginia. McCollins claimed Bayer violated West Virginia's consumer protection laws when it sold Baycol, a defective drug. 1 month after McCollins filed his case, Keith Smith sued Bayer in a different state court on claims similar to those in McCollins' suit. Smith and McCollins were unaware of each other's lawsuits. At Bayer's request, McCollins' case was removed to federal court in Minnesota after it was consolidated with other similar cases. However, Bayer couldn't remove Smith's case to federal court because Smith also sued parties that were West Virginia residents. The federal court denied McCollins' motion to certify a class under Federal Rule of Civil Procedure 23 because members of the class had suffered a variety of individual harms. After the court denied the motion to certify a class in McCollins' case, Bayer requested that the federal court enjoin the West Virginia state court from hearing Smith's motion to certify a class. The district court granted the injunction. Smith appealed, but the Court of Appeals affirmed the district court's holding. The Court of Appeals held that the relitigation exception in the Anti-Injunction Act allowed the district court to enjoin the state court. Smith's case was based on the same legal theories, and Smith was trying to certify members of the same class as McCollins. The court held that Smith's case was sufficiently identical to McCollins' case, so the federal court could enjoin the state court. The United States Supreme Court granted cert.